Breaking news tonight. A major win for the Second Amendment just came out of California. Yes, you heard that right, California. A state court has issued an injunction striking down a key gun control law, marking one of the most unexpected legal turnarounds of the year. This isn't some small technical victory that only affects a handful of people. This is a sweeping decision that halts enforcement of one of California's most aggressive gun restrictions, and it's sending shockwaves through the gun control establishment. This could set off a domino effect that impacts laws far beyond California's borders, forcing other states to reconsider their own restrictions in light of this ruling. The implications are massive, and the legal battle is just getting started. So let's break down exactly what happened, what this injunction means for gun owners across the country, and what comes next in this rapidly changing legal fight. If you care about your constitutional rights, you need to hear this story. Let's start with the background. What was this case actually about? This case focused on California's latest attempt to tighten gun control, a law that placed severe restrictions on firearm purchases, imposed magazine capacity limits, and even targeted components for home build. The law was part of a broader legislative package that California lawmakers passed in response to the Supreme Court's Bruen decision, which struck down New York's concealed carry restrictions and established a new standard for analyzing Second Amendment cases. California lawmakers thought they could get creative, working around Bruen by crafting restrictions that they claimed were consistent with historical tradition. They argued that the law was necessary for public safety and that it didn't burden the core right to keep and bear arms. But critics immediately saw through the strategy. They argued the law violated both the Bruen precedent and long-standing Second Amendment protections. The restrictions were broad, vague, and clearly designed to make it as difficult as possible for law-abiding citizens to exercise their constitutional right. 4 months after the law was passed, enforcement moved forward. Gun owners faced new hurdles, retailers struggled to comply with confusing regulations, and the state acted as if the law was perfectly constitutional. But gun rights organizations weren't going to let this stand. They stepped in and took it to court, challenging the law on constitutional grounds and demanding that enforcement be halted. Then came the stunning ruling. In a decision that shocked legal observers and gun control advocates alike, the California court granted an injunction halting enforcement of the law statewide. The judge ruled that the law directly conflicts with the Supreme Court's Bruen framework, which requires gun regulations to be consistent with the nation's historical tradition of firearm regulation. This means the state can no longer enforce these restrictions, at least temporarily, while the case moves forward through the legal system. That's a massive shift in California, where gun control has been a political priority for decades. This is a clear rebuke to the state's gun control agenda, and it sends a powerful message that courts are finally willing to enforce the Second Amendment as written. The injunction doesn't just apply to one county or one group of plaintiffs. It applies statewide, affecting millions of gun owners and fundamentally changing the enforcement landscape in California. For the first time in years, California gun owners can breathe a little easier, knowing that at least one court is willing to stand up for their rights. So, what was the legal reasoning behind this ruling? The court pointed to one key factor that has become the cornerstone of post-Bruen Second Amendment litigation: historical tradition. The judge wrote that California failed to prove that such firearm restrictions existed during the founding era or even during the period shortly after the ratification of the Second Amendment. The state tried to argue that similar regulations existed in the past, but the court found those arguments unconvincing and poorly supported by historical evidence. By Bruen standards, that failure is fatal. The Supreme Court made it clear in Bruen that gun regulations must be consistent with the nation's historical tradition of firearm regulation. If the government can't point to analogous restrictions from the founding era or the early republic, the regulation is presumptively unconstitutional. The California court took that standard seriously and applied it rigorously. This is exactly the type of decision that gun rights attorneys hoped to see in the wake of Bruin. For years, lower courts had been finding creative ways to uphold gun control laws, even when those laws seemed inconsistent with the Constitution. But this decision shows that some courts are willing to enforce Bruin faithfully, without bending over backwards to save gun control measures that don't pass constitutional muster. The reaction from the gun rights community was immediate and overwhelmingly positive. Gun owners across the country are celebrating this as a huge victory, not just for California residents, but for everyone who believes in the Second Amendment. Groups like the Firearms Policy Coalition, Gun Owners of America, and the National Rifle Association all praised the injunction, calling it a watershed moment in the fight to restore constitutional right. They say this shows the courts are finally enforcing Bruin, not letting states dance around it with clever legislative drafting or misleading historical argument. Social media exploded with posts from gun owners calling it a turning point for Second Amendment enforcement, with many expressing hope that this is the beginning of a broader legal shift. For years, California has been ground zero for gun control innovation, with other states watching and copying Sacramento's playbook. But now, the tide may be turning. If California can't defend its gun control laws in court, what does that mean for similar laws in New York, New Jersey, Illinois, and Washington? The gun rights community sees this as proof that the post-Bruin legal landscape is fundamentally different, and they're energized to keep fighting. But of course, the state of California isn't going down without a fight. State officials, including the Attorney General, immediately vowed to appeal the decision and to seek an emergency stay that would allow enforcement to resume while the appeal is pending. They're calling the decision reckless and claiming it will endanger communities by making it easier for people to access firearms. They're framing the injunction as a threat to public safety, arguing that the judge ignored the real-world consequences of striking down the law. But critics say the real danger is government overreach, and this injunction puts Sacramento on notice that it can't keep passing unconstitutional laws and expecting courts to rubber stamp them. Expect emergency motions, appeals to higher courts, and plenty of political noise as this case moves through the system. But for now, enforcement is stopped. For now, the Constitution is being enforced. And that's a win, no matter how much the state wants to spin it otherwise. The state's aggressive response also reveals just how important this law was to California's broader gun control strategy. Losing this case could unravel years of legislative work and expose other laws to similar challenges. This ruling doesn't just affect California, it could reshape how other states defend their own gun restrictions in federal and state court. Courts in New York, Illinois, Maryland, and Washington are already watching this case closely, because the legal reasoning used by the California judge is applicable far beyond state lines. If this injunction holds up on appeal, it sets a powerful precedent that states can't sidestep Bruin through creative language, vague public safety justifications, or so-called sensitive place arguments that turn entire cities into gun-free zones. The Bruin decision was supposed to change how courts analyze Second Amendment cases, but many states have tried to ignore it or work around it. This California injunction shows that at least some courts are taking Bruin seriously and applying it faithfully. That means gun control laws across the country are now vulnerable to challenge in ways they weren't before. States that have relied on weak historical arguments or questionable analogies to defend their laws are now on shaky legal ground. And gun rights organizations are taking note, preparing to file challenges to similar laws in other jurisdictions. This case could be the beginning of a legal avalanche that sweeps away decades of unconstitutional gun control. The political fallout from this decision is already underway. Mainstream media outlets are framing this as a setback for gun safety advocates, with headlines warning of dangerous consequences and lamenting the erosion of gun control. Meanwhile, alternative outlets and conservative media are calling it a major Second Amendment comeback, a sign that the Constitution still matters and that courts are willing to enforce it. In Washington, several lawmakers are already weighing in, with anti-gun politicians calling for new federal restrictions to fill the gap left by court decisions like this one. They're pushing for legislation that would impose nationwide restrictions similar to what California tried to do at the state level. But this decision sends a clear message. The Constitution isn't optional, and courts are beginning to enforce it as written. No amount of political pressure or media spin can change the text of the Second Amendment, and no amount of legislative creativity can override constitutional protections. The political battle over gun rights is far from over, but this injunction is a reminder that the legal battle is swinging in favor of gun owners. So what happens next? The next step is the appeal process, and that's where things get really interesting. The case is likely to head to the Ninth Circuit Court of Appeals, which has a long and well-documented record of siding with the state in gun control cases. For years, the Ninth Circuit has been one of the most anti-gun appellate courts in the country, routinely upholding restrictions that other circuits would have struck down. But since Bruen, even the Ninth Circuit has been forced to revisit its previous rulings and reconsider its approach to Second Amendment cases. The Supreme Court has already reversed several Ninth Circuit decisions in recent years, and there's a growing sense that the appellate court is under pressure to align its rulings with the Supreme Court's clear guidance. Legal experts say this case could eventually reach the Supreme Court, especially if the Ninth Circuit reinstates the law and creates a circuit split with other appellate courts that have struck down similar restrictions. That would set up another landmark showdown over the scope of the Second Amendment, the proper application of the Bruen Standard, and the limits of state power to regulate firearms. The stakes couldn't be higher, and both sides know it. This is a big moment for gun owners nationwide, a reminder that the fight for the Second Amendment is far from over, but that victories are possible when we challenge unconstitutional laws in court. The California injunction proves that when we stand up, when we file lawsuits, when we demand that courts enforce the Constitution, we can win. This isn't just about one law in one state. This is about the principle that constitutional rights matter, that government power has limits, and that courts have a duty to protect individual liberty against government overreach. But make no mistake, the fight isn't over. The state of California is already regrouping, filing appeals, and preparing to take this case as far as it needs to go. The Department of Justice may even get involved, filing amicus briefs in support of the state's position. Anti-gun organizations are mobilizing, fundraising, and strategizing for the next phase of this battle. That's why it's so important to stay alert, stay informed, and stay engaged. We'll keep bringing you every update as this case moves through the courts, because this is a story that's going to shape Second Amendment law for years to come. So subscribe to this channel, hit that notification bell, and as always, stay free. Thanks for watching, and we'll see you in the next one.